When we negotiate physician employment contracts, one of the questions that arises most frequently is about non-competition agreements or non-competes. I'm Erin Jackson with Jackson LLP Healthcare Lawyers. As attorneys who advise physicians, other providers, and small practices about employment issues and employment contracts specifically, something that comes up so often is my non-compete enforceable? Or when we negotiate a contract for a physician with a new hospital or practice group, can you do anything to limit or change this? So when we negotiate a contract on behalf of a provider, we look at the full spectrum of the contract. We never just negotiate or look at just one piece, even though sometimes we're asked to, because no piece of the contract exists in isolation from the others. So, when we're looking at a contract, one of the things we look at is the non-competition agreement. And in order for it to be enforceable, generally this means it needs to be reasonable in both time and scope. So reasonable in time means that it doesn't say you shall not compete for a period of 25 years or as long as your license to practice remains viable. 2 years, 5 years, these all depend on what kind of compensation the practice is giving you and what sort of consideration you're receiving in exchange for signing this non-compete. Now, scope is a little trickier. So there's a few different aspects of scope. One is geographic, the radius around the practice in which you're promising not to compete with your future employer. So this becomes trickier for physicians who are working with larger hospital systems who will ultimately end up spending anywhere from 5% to 80% of their time actually working at other locations. Or it can be an issue for someone who begins work at one location and then is transitioned to another location. The non-competition agreement was negotiated with an eye towards the intended initial place of employment. So if you only draw a radius around that, the employer, who may be you or it may be your future employer, may say, well, that's not fair. You've actually been working out of this other location for the past 2 years, and so you can't compete with this location. So the contract should really spell this out. It's also possible that the radius will intersect with state lines, county lines, municipalities, various things. So we would want to look at it to ensure that it's fair for both parties, that it keeps the employee from directly competing with the employer-to-be for a limited amount of time during the post-employment period. Now, another way to look at scope is the scope of those to whom it applies. So is it competing if a gastrointestinal surgeon leaves the employment of a large hospital system to instead operate a cash-based bariatric surgery practice within the geographic radius? Well, it's possible that if that individual was seeing primarily Medicare patients for ulcers or other gastric issues at the hospital and now wants to see an entirely different subset of patients, that this wouldn't be competitive in terms of the scope of patients being seen. Again, it's really important to consider these things and to consider, if you're a provider, where you envision your future and career and opportunities being. So when representing a physician, we try to narrow this as much as possible. Obviously, we are also representing practices. So when we represent the practice, we work to make it as expansive as possible, because protecting the practice's interests means limiting competition from former employees. Another detail to be mindful of is what could trigger its application. So if the employee is terminated for cause or not for cause, maybe for a budget reason, if they leave voluntarily, or if they're called to military service, or any other variety of outcomes, it's important to consider the circumstances that would actually trigger the application of the non-competition agreement, and then if there's circumstances in which neither party would want it to apply. So This is not even a deep dive into one of the really important clauses in most healthcare providers' employment contracts. To learn more or to chat with our attorneys about both how we can help you negotiate your own employment contract or how we can help your practice establish comprehensive, enforceable employment contracts for your providers, visit our website, jacksonllp.com, and book a free consultation. For tips about staying compliant, subscribe to our YouTube channel.